Hello, everyone. My name is Caitlin Yang,
My name is McKenna Lomeli.
My name is Mariela Carrillo.
and our topic is on gender equality. So here is an overview of what we'll be discussing in this presentation. We'll be talking about the context of gender equality movements, relevant constitutional provisions, relevant Supreme Court decisions, relevant legislation, and relevant executive orders. So a little bit of background on gender equality movements. Women have actually been fighting for equality for over 100 years in America, and gender equality movements heightened a lot after the Civil Rights Act. And this is because a lot of feminists argued that discrimination against sex is just as bad as discrimination against race. And therefore, this heightened the process and movement. And even after gaining some rights, women still faced inequality within the workforce, such as the inability to be promoted or just unfair treatment, such as getting bad jobs within the company or organization. Some relevant constitutional provisions on gender equality, there is the Equal Rights Amendment, which was proposed in 1923. And this is a proposal by Alice Paul and Crystal Eastman for the Constitution to ensure equal rights for all genders. However, this has not become an official constitutional amendment because 38 states were not able to ratify this proposal by the deadline. And even though it hasn't been able to become an official constitutional amendment, this still encourages the fight for equality. And then there is the 19th Amendment, which allows voting rights for both men and women. However, during this time, women of color were excluded. And then there is the Civil Rights Act of 1964, which prohibits discrimination based on race, religion, sex, and national origin. And then under this act, there is Title VII, which prohibits discrimination of sex within the workplace, because as I mentioned before, a lot of women were being treated very unfairly in the workforce. And because of this, this has allowed for a lot of women to become active in a lot of aspects within the country, such as politics, healthcare, military, and just about anything. And this evolution has really helped in shaping our country today.
Some relevant Supreme Court decisions is the Reed versus Reed case. So this one was argued on October 19th, 1971, and decided on November 22nd, 1971. So a summary of the Reed versus Reed case, it was based on a separated married couple who had a difference of opinion on who would be the administrator of their deceased son's estate. The Supreme Court appointed Cecil Reed, who is the father and husband of the estate of their son, because Idaho code states that males must be preferred to females. Sally Reed's lawyer argued how the 14th Amendment forbids discrimination based on sex. This was the first time in history that the Supreme Court ruled in favor of women and had addressed this topic. The Supreme Court had an anonymous decision vote of 9-0, which caused the Supreme Court to rule that it is unlawful for states to pass laws that discriminate against women under the 14th Amendment. The next relevant Supreme Court decision I chose was the Lawrence versus Texas, which was argued on March 26, 2003, and decided on June 26, 2003. So a summary of this case was based on two guys named John Lawrence and Tyrone Garner. They were both participating in private and consensual sexual activity who were then interrupted by Houston police. The police responded to a weapon disturbance call in a private residence. And as the police officer walked in, he saw the two men. They were then arrested and convicted of deviant sexual intercourse in violation of Texas law. This had the Supreme Court stop the sodomy law in Texas with a 6-3 decision vote, which then led to every other state in U.S. territory to destroy the sodomy law. The sodomy law is a law that defines certain sexual acts as crimes. Because of this Lawrence versus Texas case, the Supreme Court ruled that same-sex sexual activity is now legal in every state of the United States, including Texas, as their law forbidding it was unconstitutional. The last relevant Supreme Court decision I chose to talk about is the Hollingsworth versus Perry. This one was argued on March 26, 2013 and decided on June 26, 2013. So Proposition 22 was a legal understanding that marriages were only between men and women, which was invalidated by the Supreme Court in 2008. That made it legal for same-sex marriage. But later on that year, in 2008, the citizens of California voted on Proposition 8, which reverted it back to how it originally was before the Supreme Court invalidated Proposition 22. The Supreme Court had a voting which led to being 5-4. After Proposition 8 passed, a gay and lesbian couple sued state officials because they claimed that this proposition went against their 14th Amendment rights to equal protection of their law. The district court couldn't defend Proposition 8 because it violated the Constitution, and the U.S. Court of Appeals for the Ninth Circuit affirmed.
Some relevant legislation is Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination based on race, color, religion, sex, and national origin. Under Title VII, it is unlawful to discriminate in any aspect of employment, including hiring and firing, compensation, assignment, or classification of employees, transfer, promotion, layoffs, or recall, and other terms and conditions of employment. Another legislation is the Equal Pay Act of 1963, which prohibits employees from paying different wages to men and women who work under similar conditions and whose jobs require the same level, skill, effort, and responsibility. Employers under this act must give men and women the same pay and benefits when their jobs are substantially equal. When they don't, employees can file a lawsuit and potentially receive back pay, a pay adjustment, and a reimbursement of legal fees. The third act is the Pregnancy Discrimination Act of 1978, which prohibits discrimination on the basis of pregnancy, childbirth, or related medical conditions. Some relevant executive orders is the Executive Order 11,246, signed by President Lyndon B. Johnson on September 24, 1965, which prohibits federal government contractors and federal government-assisted construction contractors and subcontractors who do over 10,000 in federal government businesses in 1 year from discriminating in employment decisions on the basis of race, color, religion, sex, sexual orientation, gender identity, or national origin. The next executive order is Executive Order 13,988, signed by President Joseph R. Biden Jr. on January 20th of 2021, which states all persons should receive equal treatment under the law, no matter what their gender identity of sex or sexual orientation. This expands the discrimination protections previously offered solely on the basis of sex into the categories of gender identity and sexual orientation. The third executive order I'd like to mention is Executive Order 14,021, signed by President Joseph R. Biden Jr. on March 8th of 2021, which states all students should be guaranteed an equal education environment free from discrimination on the basis of sex, including discrimination in the form of sexual harassment, which encompasses sexual violence, and including discrimination on the basis of sexual orientation or gender identity.
Here are our references for everything that we stated throughout the presentation. Thank you.